Hi there, everyone. Can everyone hear me in the back? Take that as a yes. Okay, well, first of all, for those that were at dinner, I do have to apologize. Some of this speech may sound familiar. The dean and I were apparently working off of the same primary source. For the rest of you, it'll be new. Students, faculty, distinguished members of the bar and the bench, other honored guests, and members of the public. My name is John Mullaney. I'm a managing editor of the Saskatchewan Law Review and a third-year student at the College of Law. It is my privilege to welcome you all to the 19th Annual Law Review Lecture. Our distinguished speaker this evening is the Honorable Thomas Cromwell, retired Justice of the Supreme Court of Canada. At this time, I would like to acknowledge that we are on Treaty 6 territory and homeland of the Métis. We pay our respects to the First Nation and Métis ancestors of this place and reaffirm our relationship with one another. I also acknowledge the generosity of McKercher LLP for sponsoring the Law Review Lecture, which is part of McKercher's Lecture Series at the College of Law. McKercher's generous support allows the College of Law to host speakers addressing important topics in law and public policy and benefits the college and the broader community. The Saskatchewan Law Review has existed in some form since 1936. In its storied early years, the publication was called the Saskatchewan Bar Review and was published by members of the Law Society of Saskatchewan. The journal focused on the practicing profession, printing any serious discussion or comment upon the affairs of the profession, no matter how critical. David Tyerman and Stuart Tom, two-thirds of the editorial board, joined the Armed Forces in 1943, and Dean Frederick Cronkite, the remaining member of the board, and the faculty of the College of Law assumed responsibility for the publication. In 1967, the publication was renamed the Saskatchewan Law Review. The change reflected the sentiment that the journal had become an academic publication, though certainly no less critical. At that time, it was decided that students would receive course credit for their work on the review. Since then, many students who are now distinguished alumni of the College of Law have served on the editorial board. This tradition continues today, where 18 second and third year students critique submissions to the Law Review, produce book notes for publication, and in some cases publish articles of their own. The publication continues to be an important medium for the legal commentary. The Law Review has published the work of many jurists, including Justice Emmett Hall, Chief Justice Bora Laskin, and Justice Bertha Wilson, and legal scholars such as Alan Cairns, Peter Hogg, and William Letterman. Articles published in the Law Review have been cited by many Canadian courts. The Law Review has hosted this annual lecture since 1998 in pursuit of its mandate to promote legal scholarship and debate. Past speakers include the Honorable Roy Romanow, former Premier of Saskatchewan, the Honorable Edward Beta, former Chief Justice of the Saskatchewan Court of Appeal, and the Honorable Marshall Rothstein, retired Justice of the Supreme Court of Canada. We are proud to include Mr. Justice Cromwell among the ranks of those distinguished speakers. On behalf of the managing editors, the editorial board, faculty advisor Professor Haven, and the administrative staff of the Saskatchewan Law Review, I welcome you all to tonight's lecture. I now invite Martin Phillipson, Dean of the College of Law, to make a special announcement.
Thank you, John. Good evening, everyone. I'm Martin Phillipson. I'm the Dean of the College of Law. I'm also a past editor of the Saskatchewan Law Review, so it's wonderful to be at the Law Review Lecture. On behalf of the college, the faculty and staff, and the students of the college, I'd like to welcome you all here this evening. College of Law is proud to be home to the Saskatchewan Law Review, which for 80 years has produced high-quality legal scholarship of interest to the provincial bar, of interest to students and scholars throughout the world. And we're excited to have the Honourable Thomas Cromwell here tonight to deliver the annual lecture. But before we get to that, I am thrilled, genuinely thrilled, to make a special announcement this evening related to our guest speaker's topic, that is access to justice. Any challenge that people have with respect to accessing existing legal services, accessing an appropriate dispute resolution process for a legal problem, and or broader systemic barriers to justice is an access to justice issue. Access to justice issues are prevalent in our society. They're not problems that simply face the marginalized, they face the middle class, and who all face major issues in accessing and navigating the justice system. For example, they may experience major delays in proceedings or an inability to afford legal representation. 1 in 5 Canadians who face a legal problem simply don't pursue it because they don't have the resources or the time to do it. Others may face social and economic issues in addition to their legal problem that negatively affects their interactions with the justice system. And that is why I'm delighted to officially announce the launch of Create Justice, the Centre for Research, Evaluation and Access Toward Equal Justice. University Council in this very room last Thursday formally ratified the creation of the Centre, and we're delighted that the College of Law will be home to the Centre Create Justice. Its primary purpose is to address key gaps in data and access to justice research in Canada. Its research will be oriented towards 2 general dimensions of access to justice: transforming legal and justice services and the removal of systemic barriers to justice. This is only the second formal centre ever to be created in over a century of the College of Law, the first being the Native Law Centre. And I assume and I hope and I guarantee that Create will have a similar impact to the Native Law Centre. This is a momentous occasion. It will help make important data more readily available for informed and credible research. It will centralize information and projects to better streamline efforts and communication between researchers and encourage research, evaluation, and action at and beyond the University of Saskatchewan. It's very fitting that Tom Cromwell is with us this evening because in many respects Tom was the inspiration for the creation of this centre. The centre was created in response to the National Action Committee on Access to Justice and Civil and Family Matters 2013 report, known as the Cromwell Report, in which the then Honourable Thomas Cromwell called for law schools across Canada to put access to justice at the forefront of Canadian legal education and to support access to justice research to promote evidence-based policy decision-making. It's also in response to the Canadian Bar Association's Reaching Equal Justice report and a recommendation by participants at the 2015 Dean's Forum here at the University of Saskatchewan College of Law on dispute resolution and access to justice. So again, we're honoured to have Tom here this evening to deliver a lecture within a week of the creation of the Create Justice Centre. Of course, I have to thank the many, many people without whom the Centre would not have been possible, and particularly the hard work and dedication of a number of individuals. I want to particularly mention Bria Lowenberger, our Access Justice Coordinator. I think we need a round of applause for Bria if anybody's met Bria. And the other members of the steering committee, Beth Bilson, QC, the previous interim dean, Professor Heather Haven, Professor Sarah Bueller, Amanda Dodge, Professor Michaela Keat, Professor Wanda Wiegers, Professor Brent Cotter, QC, Professor Glenn Luther, QC, and Professor John Clayfeld. I'd also like to thank Rochelle Blocker for her help with the initial conception of the Centre, Taylor Agny for her assistance with drafting the proposal for the Centre, and Bonnie Hughes for drafting, editing, and general support throughout the Centre application process. I also appreciate the support of members of the Saskatchewan Access to Justice Working Group, the campus community, and everyone who forwarded a letter of support for Create Justice. Let's have a round of applause for all those folks, please. And last but not least, I really want to recognize the support of the Law Foundation of Saskatchewan, has provided significant financial support of this initiative. The Law Foundation has committed over $500,000 to funding the Access to Justice Coordinator position for 5 years, and it was with the help of the person in that position, who was funded by this funding, Bria Lowenberger, this Centre initiative was made possible. That's a wonderful start to give an academic centre. I commit as Dean that we will raise more money to make this one of the leading places for research and scholarship in Canada on access to justice. But again, the Law Foundation has given us a wonderful start, and I'd like a round of applause for the Law Foundation. Okay, without further ado, I will pass things along to Mr. Kevin Fenwick, Deputy Minister of Justice and Deputy Attorney General and Co-Chair of the Dean's Forum and Working Group, for his remarks.
Thanks very much, Martin. This is truly exciting news. I must admit it wasn't entirely news to a few of us who knew that the good news was coming tonight, but truly exciting news for a number of reasons. And I actually sit on the Law Foundation as well in my position as the Deputy Minister, so just on behalf of the Law Foundation, thank you for the kind words. The Law Foundation has revisioned itself over the last 3 or 4 years from what a lot of people perhaps would have thought years ago was a stodgy group of three-piece suitors sitting around funding the way things always were. And that's not the case anymore. The Law Foundation has reimagined ourselves as an agency that should be supporting change, and I can't think of a better example of supporting something that can be standing for innovation and fomenting change as the Center of Excellence for Access to Justice. So thank you very much to the same group of people, Bree and Heather and all of the others, for the work that went into making this happen. One of the reasons I think that it's so exciting is we are truly the envy of much of the rest of Canada because of the collaborative nature that we have in Saskatchewan between the major players in the justice system. We have 3 chiefs here of our courts in Saskatchewan, all 3, the Chief Justice of Saskatchewan, Chief Justice of the Court of Queen's Bench, and the Chief Judge of the Provincial Court. And I'm fortunate enough to have an opportunity to discuss various matters with them from time to time. And one of the things I hear regularly from them is that some of their colleagues in the rest of the country marvel at the close working relationship we have in this province between the bench and the law school and the government of Saskatchewan. We truly all see ourselves as partners in endeavors such as this. And the Center of Excellence has the opportunity just to take us to that extra level, to help us make decisions that are well informed based on research. One of the buzzwords you hear in any kind of organization these days is that we need to make evidence-based decisions, and we don't always have that information available to us within the justice system. The Center of Excellence will serve us well in that regard and do so, allow us to make even better decisions than we've been doing before. So it's a good fit for Saskatchewan because of that collaboration. It's a great fit for this law school and this university that has always, I think, been seen to be innovative. So I'm very, very proud to be able here tonight to help celebrate that. And I do want to say, although I'm not doing the formal introduction, I want to say very much thank you to Mr. Justice Cromwell for the very, very important role that you have played in moving this forward. And also thank you for, we met with Justice Cromwell this afternoon at our Access to Justice Committee, and I made the point at that time that he should be an honorary Saskatchewanian. He has been so generous of his time helping us out in Saskatchewan. I wished I'd brought a Rough Riders jersey or a Huskies jersey or something up here to present to you tonight, but thank you very much for that support and for the work that you've done across Canada in moving the Access to Justice agenda forward. So this is truly an opportunity for celebration, and we should relish in it tonight. Thank you. Looking forward to the talk.
Good evening, everyone. I'm Evan Hutchison, along with John, who you've already met, and Mike, who I imagine will make his way onto the stage sometime tonight. I'm one of the managing editors of the Law Review this year, and it's my great pleasure to introduce our lecturer tonight. It's sometimes said of people like tonight's speaker that they need no introduction. And that may be true, but I think his extraordinarily distinguished career has certainly entitled him to one. He's been a scholar and an educator, a leader in the legal community and on the bench, an eminent jurist. He is, of course, an accomplished organist and the recipient of more awards than this short introduction permits me to list. He's also, through his work with the Canadian Bar Association and other organizations, made a pivotal contribution to galvanizing and sustaining a national conversation about access to justice in Canada. And the report that's come to bear his name, as Dean Phillipson told you, inspired the creation of the research center that was announced tonight. So please join me in welcoming Mr. Justice Thomas Cromwell.
Thank you very much indeed for that warm introduction and for your overly generous, mostly inaccurate words. I thought that, in light of my recent retirement, I'd like to do a little bit of audience participation with you, if you're willing. So do you remember how to do the knock-knock thing? Okay, so knock-knock. Tom Cromwell. How soon they forget. Some of you saw that coming. Your audiences are getting too smart for me, I'm afraid. It is said that that a judge is a lawyer with a promising career behind him, and I'm not quite sure where that leaves a retired judge. But in any event, I'm delighted to be here. It's a wonderful honor to have the opportunity to give the 19th annual Saskatchewan Law Review Lecture. This lecture in my judicial career exactly coincide as I celebrated my 19th year as a judge this past August. So I'm sort of the same vintage as the founders of this lecture series, and it's a special honor to be able to be part of it. The late William R. Letterman QC was mentioned. Bill was the Rhodes Scholar from Saskatchewan. He went to Exeter College at Oxford. He then became the founding dean of my law school, Queen's Law School in Kingston, Ontario. He was my constitutional law professor, and he was the reason that I went to Exeter College at Oxford, which somehow has become the Saskatchewan College at Oxford. There is the nicest lecture room in the college is the Saskatchewan room. And so in addition to Bill, Otto Lang was there, and many other distinguished lawyers from Saskatchewan. So I'd be very open to that honorary Saskatchewan citizenship that you offered me, Kevin. Thank you. It's also a tremendous privilege to be here, to be witness to the announcement that has been made this evening about the founding of the Centre for Access to Justice, CREATE. This is I think, an enormously important thing, not just for the province of Saskatchewan, but for the country. CREATE is going to be well placed, I think, to build on the very strong collaborative foundations that you have here, thanks to things like the Dean's Forum, thanks to things like the Access to Justice Working Group. And there are so many opportunities for fundamental academic research, but also research which is not only fundamental in the academic sense, but also action-oriented that can inform policy making. And you really do have a wonderful opportunity here in Saskatchewan when you have all the key players at the same table to engage in that important work and then watch its impact unfold at the policy and operational level. So I'm going to follow the work of the Centre with tremendous interest, and it's wonderful to be here. We've just come out of your first ever Access to Justice Week. Are we still in that week, or just one more day or so? And then the foundation of the Centre. I really should just kind of go back to Ottawa. I mean, what could I possibly have to tell you folks about how to tackle access to justice? But it's wonderful to be here and to have the chance to say a couple of words to you. I'd like to talk to you about two main things tonight, I hope fairly briefly. And one is just to bring you up to date a little bit about the work of the Action Committee on Access to Justice in Civil and Family Matters that I chair at the invitation of the Chief Justice of Canada, the Right Honourable Beverly McLaughlin. And then I'd like to talk a little bit about next steps. And in some ways, I have a feeling that here in Saskatchewan, you may be way beyond the next steps that I'd have in mind for many places, but I hope that some of these reflections will nonetheless have some relevance to you here. As many of you know, the Action Committee on Access to Justice in Civil and Family Matters was convened at the invitation of Chief Justice McLaughlin in 2008. And as the junior, most recent appointment to the Supreme Court, I was invited to chair that committee. It is the broadest coalition of justice system participants ever assembled at the national level in Canada. It has high-level representation from government, the judiciary, the bar, legal organizations, including legal aid, pro bono, public legal education groups, access to justice groups at the provincial and territorial level, and from members of the public. It has now been 3 years since the committee published its report, A Roadmap for Change, in October of 2013. It's been mentioned that this is sometimes referred to as the Cromwell Report. The professor at Osgoode Hall Law School Dr. Trevor Farrow, who was very involved in the creation of the report. I often tell Trevor that if things hadn't turned out quite so well, it would now be known as the Farrow Report, and that would probably be a much fairer description of it. But in any event, our report, Roadmap for Change, came out in October of 2013, and as the title indicates, it was a call to action and a call for a strategic direction for meaningful change in access to civil and family justice. The report was well received. In fact, one leading American scholar on access to justice, Richard Zorza, whose work some of you will know, said that the report was a model for the world, which I took to be fairly complimentary. The Action Committee has now been reconstituted, its mandate clarified, and its membership broadened and renewed. The Chief Justice has asked me to carry on as chair, and so the committee, to their regret, no doubt, will have to put up with me for a little while longer yet. We're receiving administrative support from the Federal Department of Justice, the Canadian Forum for Civil Justice, the Canadian Institute for the Administration of Justice. We receive financial support from the legal profession and the judiciary, and all of the participating organizations fund the attendance and contribution of their respective representatives. Saskatchewan is ably represented in this effort and is making highly valued contributions to the Action Committee's work, a couple of which I'll touch on in a moment. One of our main recommendations in our report was that each jurisdiction ought to have a broadly representative group to promote, guide, and coordinate reform in civil and family justice. And I'm very happy to be able to tell you that this recommendation has been adopted and implemented by virtually every province and territory. Here in Saskatchewan, I've watched with pleasure and admiration as you've established the Access to Justice Working Group, building on the wonderful work that's been done and continues to be done by the Dean's Forum. I had the privilege of attending the third meeting of the working group today, and it was inspirational and highly encouraging to see that group functioning in such a collaborative and action-oriented fashion. The Action Committee itself, at the national level, is concentrating its own efforts on 4 main activities, and I want to just mention them very briefly so you'll have some sense of what we're trying to do at the national level. First of all, we convene an annual meeting of members of the Action Committee and representatives of the provincial and territorial access to justice groups. We've now had 2 such meetings, and they've proved to be important opportunities for sharing information and best practices from coast to coast to coast. We've been pleased by the wide range of access to justice initiatives that are underway across Canada and which have been showcased at these meetings, and also by the enthusiasm that representatives have for sharing their experience with their colleagues from across the country. In addition to promoting the sharing of best practices, these meetings have also served to encourage jurisdictions to keep working on this important subject. One thing we find is that, in many ways the workers are few for this work, and most people are doing it off the side of their desks in their spare time, and they find it very encouraging to meet with their colleagues who share that commitment and enthusiasm for the work. Secondly, the Action Committee has retained the Canadian Forum on Civil Justice to prepare the first ever status report on access to civil and family justice in Canada. A draft of that report will be ready for our next annual meeting in March of 2017, and it will be built around the 9 justice development goals articulated in the Roadmap for Change. We hope that this document will not only share the experiences of the many jurisdictions and groups working on access to justice, but that it will also help all of those doing this work to see how their efforts fit into an overall access to justice strategy. Third, the committee is convening a roundtable on justice innovation aimed mainly at members of the provincial and territorial access to justice groups, but open to others. You may remember that we concluded in our report that the justice system is in critical need of more innovation. We hope that this roundtable will help encourage this to happen. And Saskatchewan's own Glenn Gardner, who is here I saw him a minute ago, Glenn, thank you, is the leader of this project, and he and his planning committee have put together a very stimulating day to be held next March in conjunction with the Action Committee's annual meeting. And finally, the committee has launched a modest but I think important public engagement initiative. The goal is to make the importance of access to civil and family justice better understood by a broader public, as well as to help coalesce support around the Justice Development Goals. You may remember that in the Roadmap for Change, we set out 9 Justice Development Goals under 3 headings: innovation, institutions and structures, and research and funding. And as was mentioned, the creation of your Center for Access to Justice responds absolutely to the sort of things we hope would happen under the research and funding Justice Development Goals. All of these goals are expressed in quite general terms, as I think they have to be at the national level, but we hope that they'll serve some quite important purposes. First, we hope that the goals provide an overall coherent plan about how to tackle the access to justice problem. If everyone working to improve access to civil and family justice were able to see how their work fits in to some overall broader plan, we believe that their sense of purpose would be reinforced, and importantly, the opportunities for cooperation and collaboration would be made even clearer. We also hope that the Justice Development Goals will resonate with the public more broadly. By putting the aspirations of the justice system into plain language, we hope that the public will be able both to grasp the importance of and ultimately to support reform efforts. And finally, the goals should enable members of the public to meaningfully engage with the direction of civil justice reform, because they can react to and suggest modifications to the goals as we've developed them. So please check out www.justicedevelopmentgoals.ca. We've set out the goals in plain language and in a way we hope that makes them accessible to everyone working on access to justice and also to a broader public. There's some social media activity to follow, and we hope that this initiative will be at least a small step towards broader public engagement. Let me turn now to the challenges ahead and offer a few suggestions about how we might respond to them. The biggest challenge, I believe, is one familiar to almost every area of public policy, and that's how to effect significant change in a very complex environment. After all, civil and family justice, particularly if we define those topics broadly, as I believe we should, throws up a number of significant obstacles in the way of change. So let me just mention a few of them. Number one, the justice system professional cultures are not often very supportive of change. The system is heavily invested in professional cultures that are generally not supportive of change. You will likely have heard the old joke about how many judges does it take to change a light bulb, with the answer being change. And I'm not sure that this attitude is limited by any means to judges. Change is disruptive, it's time-consuming, and it's complicated. Few people like anything with even one of those qualities, let alone all three. But in my judgment, we've made some real progress on this front in confronting this obstacle. When I began chairing the Action Committee nearly 8 years ago, there was widespread reluctance to admit the seriousness and the urgency of the access to justice problem. That, as far as I can tell, has changed dramatically. Nearly every leader of every sector of the system recognizes the problem and the urgent need to do something about it. Well, while recognition of a problem is not a solution to it, I'm evidence of that. I recognize that I'm too heavy, but I haven't yet really buckled down to do anything about it. I was at my law school 40th reunion last weekend at Queen's, and my name appeared on the list of attendees as Ton Cromwell. They claimed it was a misprint. But in any event, while of course recognizing the problem is not solving it, it's a very important and in fact essential first step to any meaningful engagement with the problem. And so I think we've made progress there. Another item of progress, I believe, is the widespread support that has been received by the roadmap's 6 guiding principles for change. As you may recall, the roadmap called for a culture shift and set out 6 principles that, if adopted and applied, would lead to that shift. We thought that professional legal culture needs to change in a number of specific respects. First, justice system must learn to put the public first, not to subordinate its own priorities to it, not subordinate that need to its own priorities and values. Second, people within the system must learn to collaborate with other professionals and the public in order to overcome a culture of independence and, in some cases, isolation. Third, we need to broaden our focus beyond the formal justice system and to recognize the importance of addressing the so-called upstream problems through educational and preventative programs, and also to recognize the non-legal aspects of people's overall problem. Fourth, we must strive to ensure that we make our system as simple, coherent, and proportional as possible so that it is capable of producing just outcomes that are proportional to the problems brought to it and reflective of the needs of the people it's meant to serve. Fifth, we need to learn to shift our focus from process to outcomes. You have no idea how hard it is for me, having taught civil procedure for 15 years, to utter those very words. Process, of course, is important, but we must not be focused on fair process for its own sake, but only on it to the extent that it assists us in producing fair and practical results for the people who use our civil justice system or would like to be able to do so. Finally, we need to overcome inertia. Professionals in some ways have a vested interest in the status quo. We have acquired skill in using the system as it is, a skill which may decline in value or have to be relearned in a changed system. And so we need to learn to overcome that sense of inertia and embrace change. The wide support for those 6 principles is a sign, I think, that the professional cultures within the civil and family justice system are in fact changing. I'm sure that we have not arrived at the end result, but I do believe that we are, at least for the most part, headed in the right direction, and as well that there is broad consensus on what is needed. Second difficulty or obstacle. We face an intricate systemic problem in a fragmented system whose leadership is diffuse. The problems we face are intricate systemic problems. They cannot be tackled by measures that are narrowly conceived or which fail to take into account their overall and often unintended impact on other aspects of the system. Systems thinking does not come easily to most of us in the justice system, but that's what is needed. In addition, the system, of course, is quite fragmented. As the Action Committee said in its report, it is hard to say, in fact, that there is a system, as opposed to many systems and parts of systems. This is especially true if we define the system broadly to include the whole suite of institutions, resources, and services that help people address their civil and family legal problems. When we do that, we are talking about a lot more than courts and lawyers. Finally, the leadership in the system is diffuse, which is a polite way of saying that no one is really in charge. Important elements of that system have a large measure of independence from other elements. The judges are properly independent decision makers. The lawyers are independent advocates for their clients. The government has unique responsibilities for the expenditure of public money, and so on. So we have all of those issues about the complexity of the system to confront. The system also has difficulty innovating. Our first 4 justice development goals, 4 of the 9 that we set out in the roadmap, are innovation goals. This emphasis in the report reflects and underlines the pressing need for innovation in the justice system. Too often, I fear, we act as if the civil justice system were, in some ways, an old trophy on a shelf. Like that trophy, the system is the result of important achievements in the past. Society's capacity to resolve disputes by independent judges, the ability of parties to be represented by skilled and independent lawyers, and the institution of fair and predictable procedures are all important inheritances that we should celebrate and work hard to preserve. But unlike a trophy, our civil justice system is not and cannot be static, and our reverence for the past must not blind us to current shortcomings. As the Action Committee said in the roadmap, the civil and family justice system is too complex, too slow, and too expensive. In other words, our civil justice system, for all of its virtues, has not kept pace with contemporary needs. And simply giving it a good polish, while that may make it look better for a little while, is not enough to make the system reflect the needs of those whom it is meant to serve. In short, there's a pressing need for principled innovation, and innovation requires resources. I'm far from persuaded, I should say at the outset, that all of our problems in the civil justice system would be solved by an influx of money. But we need to recognize that the need for resources to permit innovation is real. We do not have the luxury of closing down our civil justice system while we build something better. And so all of our strategizing and innovation has to take place while under the daily pressure of the ongoing work of the system. And as many of you in this room know much better than I do, this makes bringing about change very challenging. I recognize that in our fiscal situation, it's unrealistic to expect a large addition to justice system budgets. But I do suggest that this reality should not lead us to simply give up the fight for more resources. Governments have a way of finding resources for the things that they think are important. At the very least, we need resources targeted at innovation, an investment that recognizes that fundamental change is not possible without additional resources to permit the sort of transformation that will end up making the system more efficient, and also that recognizes that things take some stability and some time. Once again, there is some good news in relation to innovation in the justice system. Several ministries of justice across Canada have senior officials explicitly mandated to lead innovation in the justice system. Saskatchewan has and is doing impressive things in this regard. In addition to this institutional commitment to innovation, we are also seeing a much broader interest in justice innovation across the justice community. And I hope that the Innovation Day that we're putting together for next March will not only respond to, but also fuel that interest. So how should we respond to the challenge of bringing about systemic change in this complex, fragmented environment which is badly in need of innovation? The most important elements, I suggest, are developing the capacity for collaborative decision-making, articulating a clear vision of the change that we think is necessary, and having a coherent plan. So to turn briefly to the capacity for collaborative decision-making, I'm going to be very brief on this because I think that case has been made and won, particularly here in Saskatchewan. In our report, the Roadmap Report, we highlighted this as one of the major barriers to significant change. We said that within our current constitutional and administrative and sectoral frameworks, much more collaboration and coordination is not only needed but achievable. We can and must improve collaboration and coordination not only across and within jurisdictions, but also across and within all sectors. Part of what is needed is a fresh look at the nature of many of the problems that confront us in the justice system. We tend to view them as legal problems with a social dimension. In fact, however, it is often the other way around. The legal problems that we address are often one, and often a very small part, of the overall problem facing the people involved. Once we make that shift in how we define and understand the problem, it becomes easier to see how the possibility and the need for better integration of the approach to the legal aspects with an overall approach to the human problem at its root. I can certainly report some progress in developing more collaborative and cooperative approaches to decision-making. As I mentioned earlier, one of the key recommendations in our report was the creation in each jurisdiction of an access to justice group with a broad-based, multi-stakeholder collaborative approach. And there have been excellent take-up on this recommendation, with virtually every province and territory setting up a group in response. The models that have been adopted vary a great deal from place to place. But in every case, an important goal is to bring together the key people and to build better coordination and cooperation. The level and the depth of that collaboration here in Saskatchewan is truly impressive and indeed inspirational. Ultimately, of course, time will tell how effective these new mechanisms will be in achieving their important objectives. A significant challenge is finding sufficient administrative and other support to allow them to operate at their full potential. But I sense that there is a deep level of commitment to both improving access to justice and to learning how to work together effectively towards that goal. And some of the things you're doing here in Saskatchewan, I think, could be models for many other places, in the sense that you're taking advantage of the availability of law students to do top-flight legal research. The Law Foundation is committing itself to an access to justice agenda. So many, many things. You have highly collaborative processes in place. So I believe that almost everything that's happening here is just a textbook of what should be happening to tackle this very complex systemic problem. Turning briefly to developing a coherent plan. Why our domestic civil justice reform efforts succeed or fail is an area that has received very little scholarly attention. Hint, hint. But there is an impressive body of literature that looks at why efforts to strengthen justice systems succeed or fail in developing countries and countries trying to rebuild after major conflicts. Now, of course, while the parallels between modern Canada and those countries are far from exact, but I suggest that this literature nonetheless offers some valuable insights into what we are doing well and what we may be doing a little less well in our own domestic civil justice reform efforts. One work that I have found to be very helpful is a review prepared by the World Bank of the lessons learned from 20 years of efforts to strengthen rule of law in post-conflict countries. This review is based on a host of evaluations of rule of law projects in many countries over 2 decades. Interestingly, the review was spawned by the belief that the numerous rule of law assistance programs had produced few lasting consequences. Does that sound familiar about civil justice reform in our country? I was only admitted to the bar in 1979, but in my professional career there have been enough reports about civil justice reform probably to fill this room, and yet there seems to be a huge gap between what we know or think we know and what we do. And so I found it very interesting that a major funder of rule of law projects around the world felt exactly the same way about their experiences of funding a host of these rule of law engagement programs in many countries over 2 decades. So the key question for the review and for us is, why is this so tough to bring about real change? The first factor contributing to failure, at least in the World Bank study, was the lack of a coherent strategy. The author said this, and it's a very brief quote: "Rule of law reform has suffered from a notable lack of strategy. Given the systemic nature of the changes that are sought to be brought about, and the inherently interconnected nature of elements of a legal system, it is difficult to achieve sustainable change if the elements are not approached in a coherent fashion." It seems to me you could take that out of the World Bank report and plunk it into an assessment of our own reform efforts in 20th and 21st century Canada. Now, of course, Canada is not a post-conflict country or one in which the rule of law is in any peril. There is, I think, nonetheless something to learn from this conclusion. Our legal system is, exactly as this author put it, inherently interconnected. And so there's good reason to think that many of the resulting challenges of achieving sustainable change arising from this aspect of the system, this characteristic of the system, might also apply here. In short, what we need is both an overall plan and a strategy to carry it out. And I think that we have quite a long way to go with respect to both of those requirements. In terms of the overall plan, I hope that the roadmap's 9 justice development goals at least provide an overall sense of direction at the national level. Of course, there's lots of room within those goals for jurisdictions and indeed for all of those working in the system for change to set their own priorities for action. As we made clear in the report, these were intended as a roadmap, not a repair manual. My sense of the situation, however, is this. We are generally lacking in any sort of overall coherent plan for reform, even when articulated at a very general level. In addition, I suggest there has not yet been sufficient engagement with the Justice Development Goals or something equivalent. And I certainly do not think that at this point they are providing any sort of overall direction or even providing a rallying point for people working for civil justice reform. Hopefully our status report next spring and our efforts to promote the goals will help improve the situation, but I have little to share with you on this point other than my cautious optimism. When there's not much in the way of a plan, there's unlikely to be much of a strategy either. And I think that this is generally the case across Canada. But what I suggest is needed once there is some large coherent plan is to develop a strategy about how to build the support necessary to implement it. And that brings me to the final section of my remarks this evening, which addresses the question of whether we need to build an access to justice movement in order to bring about major change that our system so badly needs. To put it bluntly, the need for systemic change in our civil justice system is not an issue of great public concern. And I fear that until it is, the sort of deep systemic change that is required will simply not occur. Nearly everyone now accepts the need to involve non-justice system stakeholders in the process of reform. We recognize that we cannot put the public first unless we know what the needs and expectations of the public are. And we cannot do that without involving members of the public in the design and implementation of reforms. While finding the proper and useful means of doing that continues to be a challenge, we at least recognize that we need to do it. But while involving members of the public in designing and implementing reforms is one aspect of public engagement and an important one, I'm speaking here about a much broader form of public engagement. I'm speaking of the need to have broad public support for fundamental systemic reform of the civil justice system. If there is to be the political will to bring about these changes, let alone the resources to make it possible, then civil justice reform needs to have a lot more public support than it currently does. One of the fundamental questions that we asked ourselves in the Action Committee was why we have such a large gap between ideas and action. We referred to this as the implementation gap, the gap between the ideas in volumes of reports and our ability to implement them. We identified a number of factors that contribute to the gap and proposed a number of strategies. But I'm increasingly persuaded that an important factor that contributes to this implementation gap is a lack of public interest and support. There has been some very interesting academic work on how justice reformers might learn from the social science study of social movements. In particular, it has been argued that social science can help us to understand why some pushes for reform succeed while others fail. And when we look at some of this literature, even in the very superficial way that I have done, there is reason to think that in relation to civil and family justice reform, some of the important conditions for success are either present or within our reach. One important element favoring successful reform is the existence of an atmosphere ripe for change. And I believe that we have such an atmosphere in Canada on this issue. There is good reason to believe that we can make the case for change strongly and persuasively, although we need to do so to a much broader audience than we usually consider. Research suggests that this is an issue that is important to a lot of people in Canada. Did you ever imagine 5 years ago that we would in 2016 have an Access to Justice Week in 2 Canadian provinces? Way to go, Saskatchewan. Second, the research suggests that social movements, and I quote here, are built on a foundation of organizers, movement organizations, and networks of communication. Once again, I think we have good reason to be optimistic that we have at least the beginnings of these important elements. There already exist broad and deep networks of people committed to civil justice reform. They're not yet sufficiently connected or ready or able to act in coordinated ways, but the potential for considerable mobilization is there from coast to coast to coast. Just think for a moment of the intersecting networks that I see as I'm chairing a meeting of the Action Committee. By proxy, thousands of people, literally thousands of people, committed to civil justice reform are at that table through their representatives. It is in reality a network of networks. And the same can be said about the provincial and territorial access to justice groups, including your own Access to Justice Working Group. We should not underestimate the potential of the many intersecting networks of people committed to reform. We can build on and take better advantage of these networks. Third, the literature talks about the need to frame the problem in a compelling way, which will help to develop the sense of collective identity among people who want change. As in lawyers' terms, this is your theory of the case on which your approach is going to be built, but called framing. As one writer put it, and I think this is the most important sentence I've read in the last month or two, one writer put it this way: organized action comes about when private grievances are redefined as a community's shared social problem. Organized action comes about when private grievances are redefined as a community's shared social problem. While I suspect that we are not doing a very good job of this, I think we have great potential to show how private grievances of those who do not have adequate access to civil justice are in fact and should be thought about as the community's shared problem. We can surely bring to light tangible, ground-level instances of injustice that will help those instances to be transformed in a collective call for systemic change. The most recent polling that I have seen in relation to access to justice was conducted in Ontario last August. It showed that most Ontarians had fairly negative views of the province's justice system, although curiously they thought they were better off than most other provinces. Large majorities thought that the system was old-fashioned, intimidating, confusing, inefficient, and 64% thought it was simply broken. If this polling is anything to go by, we surely have fertile ground indeed for the message that inadequate access to justice is a community's shared problem. Finally, social movement scholarship suggests that people need a means by which they can engage in collective action. While we are not generally providing those means at this point, I would say that there is great potential in the broad and wide networks of people committed to civil justice throughout Canada to do exactly that. So let me leave you with this thought. We need more than some forward movement on civil justice reform. We need, I believe, a civil justice movement. And while I'm not suggesting, after all, I was a judge of our highest court, I'm not suggesting that we camp out in parks or picket, although picketing perhaps. I am suggesting that we need to engage the public with both the importance of the civil justice system and the need for and the benefits of fundamental reform of it. And so I leave you with the challenge, all of us who care about access to civil justice, to either lead this movement or at least be part of it. There is no more worthy cause. Thank you.
Hi there, everyone. I'm Michael Crampton, the third and final of the managing editors of the Saskatchewan Law Review that you'll have to hear from tonight. It's my great pleasure to be the one to thank all of you for attending tonight's lecture, to thank Justice Cromwell for those thoughtful, engaging, and frankly very challenging remarks. I think that you have challenged all of us in this room tonight as participants in the justice system, either narrowly or broadly, to carry forward with this movement that you have articulated. On behalf of the managing editors, we'd just like to personally thank Katie Riley, the College of Law's events coordinator, who does just incredible work and really facilitated a lot of this evening. And that almost brings our program for the evening to a close, but with the final last little bit that we'll keep you here for, I would like to invite to the stage the College of Law's Access to Justice Coordinator and organizer of Access to Justice Week Saskatchewan, Bree Lowenberger, and the Assistant Dean of the College of Law Research, I think it is technically, and Faculty Editor of the Saskatchewan Law Review, Professor Heather Haven.
I'd just like to start with remarking how very meaningful it is to have the Honourable Thomas Cromwell, recently retired Justice of the Supreme Court, here with us tonight on this momentous occasion. As he mentioned himself, he was here during an equally momentous occasion back in 2014, during the first meeting of the Dean's Forum that involved student participants. Justice Cromwell's participation at that event created a real excitement and energy around the initiative that I just don't think would have been possible without his participation at that meeting. And that participation has had obviously lasting impact at the U of S and at the College of Law. And so we would just like to extend our great appreciation for your leadership, both locally and nationally, through your leadership as chair of the National Action Committee.
And we'd like to call you back up on stage for a minute. Well, we did too, but it sounds like you were actually calling us all to action to start a big movement. So a retired judge from the Supreme Court of Canada is calling us all to action to maybe be a bit of a rebel. Maybe that's what you were in your formative years. So maybe there is a new career path ahead of you in terms of starting this access to justice movement. Now, Kevin Fenwick had a really good idea about making you an honorary member of Saskatchewan, but we're not going to do that. We had a different idea. We're making you an honorary fellow of our new Create Justice Center. Okay. Here, you go in the middle, because you're the most important. Okay. Great.
This is great. I usually these honorary things, the salary and the duties exactly coincide. But I promise to be a real pain in the neck. Thank you very much.
So that ends our all the presentations and announcements and speeches for the evening. So I just want to thank everyone for coming out to our 19th annual Saskatchewan Law Review Lecture. We hope to see you all here next year, maybe same time, same place, and we'll have other challenging things to challenge you with next time. So thanks everyone for coming out, and enjoy the rest of your evening.